Well, good morning, everyone. Welcome to our town hall for Notaries Public. My name is Kathy Smith, and I am honored to be Maryland's Assistant Secretary of State. I provide executive oversight of the Charities and Legal Services Division. Today's town hall will address types of notarizations, allowable actions a notary may perform. As indicated in the email notification about today's town hall will be recorded. A link to the recording will be available on the Secretary of State's website under the Notaries tab. By choosing to participate in today's town hall, you are consenting to the recording. The content and presentation is for informational purposes only. It is not intended to be legal advice. With me today is our Division Administrator, Michael Schlein, and our notary officers. In response to some emails and some questions that were in the chat this morning, attendance is not required, and this town hall is not the course of study or the course of study that was required in the October 2021 law. Let me repeat that. This town hall is not the course of study, and it is not a substitute for the course of study required by the October 21. This town hall is my attempt to reach out to our notaries public and all those interested in activities regarding notaries. Time is reserved at the end for questions, and you may find that your questions are answered as the presentation progresses. You may place questions in the chat box, but in order to prevent confusion about the source of the response, please do not answer questions placed in the chat box. Let me repeat that again. To prevent confusion about the source of the response, do not answer questions placed in the chat box. Occasionally, we've had well-intentioned people give some misinformation. So only notary officers will respond to questions in the chat box. Our notary officers will announce questions at the end of our session that are in the chat box, and we'll do our best to answer them. Of course, during our Q&A session, we'll invite other. If you have questions about TIPIC, TIPIC, of course, is the Title Insurance Producers and Independent Contractors, please refer them to the Maryland Insurance Administration. TIPIC falls under their scope of responsibility and authority, not the Office of the Secretary of State. Let me repeat that again. If you have questions about TIPIC, the Title Insurance Producers and Independent Contractors, refer them to the Maryland Insurance Administration. That is their scope of authority and responsibility. The Office of the Secretary of State has no authority regarding TIPIC. That said, you're welcome to view the recording of the February 21st Town Hall regarding notaries and TIPIC. You may find the recording on the SOS website under the Notaries tab, and I'm sure you'll find it very informative. Our notary officers, again, will respond to any questions that are placed in the chat box, and we'll announce them at the end. And once more time, the recording of today's call will be posted on the SOS website under the Notaries tab. As we begin, if you'd like to keep your camera on, you're welcome to do that. But please mute your microphone. So without further ado, please allow me to introduce our fabulous Division Administrator, Michael Schlein. Mike?
Thanks, Kathy. Good morning, everybody. Hope everybody's doing well on this Monday in May. So today we're going to talk about allowable actions a notary may perform. We're going to talk about different types of notarial acts, both just, in person versus remote and electronic and what that means, but also the different types of notarial acts that you can perform, oaths, acknowledgments, affirmations. And we're going to cover all those briefly during this town hall. So let's get into it. So sources of legal authority, notary public law is found in Title 18, subtitles 1 and 2 of the state government article of the annotated code in Maryland. And there are also regulations found in the Code of Maryland regulations 010208. And you can actually look up the laws of the state of Maryland at that first link on this page, and look up the regulations at that second link, that second hyperlink here. And if you If you don't write these down quick enough, again, don't worry. This is going to be posted. The recording is going to be posted online. You'll be able to get this link. It's also on the main notary page of our website. We have links to the laws, so you can look up the law, any law really, not just notary law, should there be a need to do that. So types of notarizations: general powers, identifying signers, authority. First type of notarization that we're going to just talk about here is the traditional in-person notarization. This is the one everybody's been doing since notary public was a thing. In Maryland, a notary may perform a notarial act, including taking an acknowledgement, administering an oath or affirmation, verification on oath and affirmation, witnessing or attesting a signature, certifying, attesting a copy of documents, protest. These notarial acts, we're going to discuss them in the later pages, but these are the types of notarial acts you can perform, and you can perform any of these obviously in person. This is where somebody is appearing before you in the physical presence of the notary public. I go to the notary in person. Notary identifies me, watches me sign, oath, affirmation, acknowledgement, whatever it is, those duties that we're going to talk about later. But I'm in person, I'm in front of the notary, and everything that's happening in this notarial act happens with me in front of that notary at that same point in time, at that same occurrence. The steps required to perform an in-person notarization, they differ depending on the type of notarial act, but generally every notarial act is going to include these 5 things. If you're in person, you're going to be in the same physical presence of the person requesting the notarial act. You're going to identify the signer using a valid government photo ID. Personal knowledge is a thing you can use as well, but generally valid government issued ID is the best way to identify someone, even if you do know them. Good to get that information. Witness the signing of the document or have the person attest to the fact that they signed it. Again, depends on what type of notarial act we're talking about. Notary is always going to affix their seal, execute the notarial act, and make an entry in the register of official acts. So the notary's journal, as it's known under the law now, but more commonly known historically as the register of official acts. So these 5 things each time, every time, no matter what. If you're in person, they're always before you. They're always identifying them. You're either witnessing them sign the documents or attesting to the fact that they signed it. You're sealing the document, you're executing the notarial certificate, you're filling that certificate out, completing the notarial act, and making the entry in your journal. Sometimes a notary may travel to do an in-person notarization. There are certain fees above and beyond the standard notary fee, which is now $6 per notarial act for an in-person notarization. But if you travel to do a notarial act, you can also charge fees for traveling. And a lot of times folks refer to themselves as mobile notaries if they're willing to travel to do a notarial act. That's not a separate license category or anything. That's just a term folks use in the industry. It doesn't have any real legal meaning. It's just, again, it's a term. Mobile people will go places to do notarial acts. And if a notary does travel to do a notarial act, in addition to the fee per notarial act, they can charge $5 because they're traveling and the IRS mileage rate for business travel. So if I'm traveling to do a notarial act, I can charge $5 because I traveled, plus mileage, plus the fees per notarial act, $6 for in-person per notarial act. And the IRS mileage rates posted on our website. But if you ever want to double check it, IRS, just do a Google search for IRS business travel rate, business mileage travel rates, and you'll get the link will pop up in your search results to verify with the IRS as well. So electronic notarizations, so in person still, but electronic, essentially are replacing the hand-signed document with electronic signature, electronic notarization. For an electronic notarization, sometimes referred to as an e-notary. It's not a separate licensing category of notary public. An electronic notarization is not what people often think of, which is remote notarizations, which we're going to talk about next. An electronic notarization still requires a notary to be in the physical presence of the signer, and the witness, the signer, affixing their electronic signature to the electronic document. So same as in person, except for electronic signature and seal, electronic document rather than the traditional paper. So remote notarial acts on electronic records. The remote notarial act is a little different. It's electronic in this case, but you're not in the physical presence of the notary. You are appearing before them using audio-visual technology. And these technologies are specifically designed and approved for remote notarial acts on electronic records. And we have a list of these technologies. We call them RON vendors, remote online notary vendors. And you can find the approved RON vendors on a list on the notary page of our website. The specifically designed and approved technology, it allows the person to sign a document in real time. The notary is able to see it in real time through this application, through this technology. The notary can affix their seal to the record in real time, and the signer sees that happen. So this technology takes your in-person notarial act, and through audiovisual technology, through these approved RON vendors, allows this act to recur while you're in two different places using this technology, but still identifying the signer, still witnessing the signature, still affixing the seal and completing the certificate on the notarial act, still keeping your journal, recording this act in your records. So this technology allows all that to happen while you're not in the same place. But again, if it's an electronic record, it needs to be a RON vendor's technology that is used. So for things like this, we're not talking about Skype or FaceTime or anything like that. RON vendor on the approved list. Remote online notary vendors, they provide technology to assist in the identification of the person appearing before the notary by using credential analysis and identity proofing. So an enhanced way of ensuring that the person appearing on the video is in fact who they say they are and who you're identifying them as. And the remote online notary vendor technology allows a notary to comply with the recording requirements in the law as well. So if you are doing a remote notarial act, that act must be recorded, and that recording, just like your journal, has to be stored for 10 years. The RON vendor technology complies or allows you to comply with that requirement by recording the act and allowing you to possess that for 10 years. And each of them might be a little different in how they do that, how they meet that requirement, but they all allow you to meet that requirement. Something relatively new in the law, remote notarial acts on tangible records went into effect June 1st of 2022. A notary public may perform remote notarial acts for a remotely located individual who is signing a tangible or hard copy document using a wet ink signature. You can only perform a remote notarial act on a tangible record for an individual that you can identify by personal knowledge or credible witness. If you do not know who they are, or you do not have a credible witness that knows who they are, you cannot remotely notarize a tangible record. So in other words, if you need to view somebody's ID to notarize for them and verify their identity, you cannot do a remote notarial act on a tangible record. The notary must record the transaction, keep that recording for 10 years. The individual appearing before the notary during this audiovisual recording must sign the tangible record and a declaration that is a part of or securely attached to that tangible record. Then that person sends the tangible record and declaration to the notary not later than 3 days after the notarial act was performed. And after receipt of that tangible record and declaration, the notary must reasonably confirm that the tangible record received is the same tangible record the individual signed on the audio-visual recording, and then execute the required certificate. That record is staying a tangible record throughout the entire process in this situation. So a few additional points on this page just to drive home again. It's a tangible record, it stays a tangible record. So if you're remotely notarizing a tangible record, you need to have personal knowledge of the signer or be able to identify them using a credible witness. The definition of those terms of identification are found in the law. We talk about them on a couple different town halls, but personal knowledge of the signer, credible witness, and paper all the way through. What does that mean? A lot of folks say, oh, okay, I signed this paper. Let me scan it and email it to you, or scan it and fax it to you. That's not how this works. It's a tangible record. It stays a tangible record from the time the person signs that on the audiovisual recording and sends it to the notary for the completion of the notarial act. It has to stay a tangible record. Doesn't get to change around throughout the process. So you have remote notarial acts on electronic records and remote notarial acts on tangible records, different processes for these. And if you are seeking authorization to perform remote notarial acts, you want to make sure you understand the difference of the two and pick the right one that you're trying to accomplish. There's a whole town hall coming up on remote notarial acts where we go into this stuff in great detail. And there's a recording from last year's about remote notarial acts that's on the notary page of our website as well. If you go to SOS, like Secretary of State .Maryland, Maryland is spelled out, .gov, G-O-V, click on the Notaries tab, and you go to Notaries page. All of our prior town hall recordings are there. This one will go there later this week, but all of our previous ones are there. You can learn a lot more about remote notarial acts. We talked about general powers and duties of a notary public. So you can take an acknowledgement, verification, an oath or affirmation, witness or attest a signature, certify or attest a copy of a record or item that was copied, certify that a tangible copy of an electronic record is an accurate copy of that electronic record, or make or note a protest of a negotiable instrument. So authority of the notary, a notary may perform notarial acts in any county of the state or in the city of Baltimore, regardless of where that person was commissioned. So let's say, for instance, I'm commissioned in Baltimore City. I can notarize anywhere from the mountains to the shore, right? I could be out in Garrett County and I can notarize. I could be down at Ocean City and notarize. I can be up in Northeast Maryland and Cecil County, or down in Southern Maryland in St. Mary City, and I can still notarize. Even though I'm commissioned in Baltimore City, I'm still a notary public for the state of Maryland, and I can notarize anywhere within the physical borders of Maryland. A Maryland notary public is not authorized to act as a notary public in another state or DC or any other territory. You must be physically present in Maryland to act as a Maryland notary public. A lot of folks will ask us, well, can I be a notary in multiple states? Sure, but if you're, we're concerned about is your commission as a Maryland notary public. So that's what we control. That's what the law covers. If you're separately commissioned in another state or in DC, then when you're acting as a DC notary or a notary in those other states, you're subject to those laws and requirements, and you would follow them.
Mike, it really bears saying too, that in order to act as a notary for another jurisdiction, another state, or the District of Columbia, you have to be commissioned in that state or in the District of Columbia. Because you're commissioned in Maryland does not authorize anyone to act as a notary for the District of Columbia or for another state. So in other words, you have multiple commissions for multiple states if that were the case. But today we're only talking about Maryland commissions, that's which we have authority.
Correct. And last point to make on these this particular slide here is a notary can notarize documents that are coming from or going to anywhere else, as long as the document is notarized in Maryland. So maybe somebody's here traveling and something happens, they need something notarized. It may be going back to with that person to wherever they're from. That's fine, notarize it, right? But you have to be physically present in Maryland when you notarize it. Doesn't matter where the document's coming from or going to. What matters for the Maryland notary is that the notary is physically present in Maryland where they have the authority to notarize as a Maryland notary public.
And I think it bears saying that when acting as a Maryland notary, the only seal you would use is the Maryland notary seal. Not a seal from any other jurisdiction, just the Maryland notary seal.
Exactly. Conflicts of interest. So talking about conflicts, a notary may not perform a notarial act with respect to a record to which the notary or the spouse of the notary is a party, or in which either the notary or their spouse has a direct beneficial interest. So a notarial act performed in violation of this provision is voidable. In other words, don't notarize for yourself, don't notarize for your spouse. Can't do it, expressly prohibited in the law. While the law prevents a notary from performing a notarial act in which the notary or their spouse has a direct beneficial interest, really a notary should refrain from performing notarial acts for all members of their immediate family, even if they're not under legal duty to refrain for that member of your family, and with regard to any matter in which the notary is personally involved, even if indirectly, or where there's no beneficial interest. Don't notarize for your family, plain and simple. You're not under a legal requirement to refrain unless it's yourself or your spouse. But the reality is, we get a lot of complaints about notarial acts, and a good chunk of them, if not a majority of them, deal with family disputes that occur over time, unfortunately. And, everything is good until it's not. And there's about 90,000 notaries in Maryland. You can find one that's not related to you to notarize that document, and you should. That way there's no perceived conflict, even if it's not a conflict that's expressly laid out in the law. Stay away from that problem. Trust me, it'll be better for you in the future to get somebody that's not a relative to notarize for you, or to not notarize for your relative. And they'll understand. I know sometimes you could be under a lot of pressure to do this for a family member, but their family, and if they have the best of intentions, as frustrated as they may be, they'll understand if you don't want to notarize it. They should understand if you don't want to notarize it for them, to avoid that perceived conflict, even if you're not expressly forbidden to do it. So a few other restrictions here. Commission does not authorize a notary to assist in drafting legal records or give legal advice or otherwise practice law. Cannot act as an immigration consultant or expert in immigration matters simply by having a notary commission. Cannot represent people in judicial or administrative proceedings. Can't receive compensation for any of those acts simply by being a notary. Now, if you're licensed as an attorney and a notary, obviously you can practice law. You're licensed as an attorney, right? Or an immigration consultant or something like that, right? You cannot use your notary commission to do these things, but you can be separately licensed to do these things.
Right. And, the interesting thing there, Mike, is that licensed as an attorney is not commissioned as a notary. So if you're a licensed attorney, you must still be commissioned as a notary. So apply, take the course of study, and the exam that's required for new notaries. So they're not mutually exclusive, but neither does one necessarily allow the other.
Exactly. Great point. Great point. A notary may not also engage in false or deceptive advertising or use these terms notarial or notarial public unless they're licensed to practice law. Advertise or represent that the notary may assist persons in drafting legal records, give legal advice, or otherwise practice law unless the notary is an attorney licensed to practice law in Maryland.
It may be worth noting, Mike, I know you're going to get to it in a minute, that the only individuals who are authorized to sign as a notary, and that is to authenticate a document and to verify the signature, to witness the signature as a notary, is a notary. So just because Mike Klein and I work together, he doesn't have the authority to witness my signature on a document that needs to be notarized unless he is already commissioned as a notary public. Nor do I unless I am commissioned as a notary public. So just because one of us might be, does not extend to the second person. So both parties, whoever is authorizing or notarizing a document, must be a commissioned notary public in the state of Maryland. I'm seeing some questions in the chat box. I hope that resolves those questions.
Be a notary. There are certain folks in the law classified as notarial officers, such as judges or clerks of the court. But that's a separate me. You know if you are one of those already, right? So otherwise, you must be a notary public you have to get your commission, and you have to be actively commissioned, having taken the oath of office and received your commission in order to notarize. So different types of notarial acts and certificates. One of the big changes, a lot of the law changed on October 1st, 2020. And one of the big changes that occurred at that time was the requirement that every notarial act be evidenced by a notarial certificate. So now every time you notarize something, a notarial certificate needs to be completed and securely attached to that document. Now, what does that mean exactly? That means it could be on the document already, right? There was a lot of times, even before October 1st, 2020, where a notarial act would come to you, somebody would be requesting a notarial act, and the notarial wording would already be on the document. Great. Perfectly fine, still allowed. What really changes isn't that. What changes is what happens when there's not a notarial certificate already on the document. And that's where the notary needs to attach and complete a notarial certificate based on the request made by the person coming before them for the notarial act. So a different type of notarial act is required. A notarial certificate is required for each type of notarial act. So what you're attaching really depends on what the person's asking. And we're going to go through these different notarial acts and certificates, or notarial acts, so you know what certificate to use here on these following slides. So really knowing what the person's asking. Are they asking you to notarize their signature? Are they asking you for an acknowledgement? Are they asking you for an oath or affirmation, or some type of certified copy type of request? Knowing what they're asking will dictate what certificate to attach. Each notarial act being evidenced by a certificate, that certificate shall be executed contemporaneously with the performance of the notarial act. So we talked about notarial acts in person and even electronic or remote, but the reality is you're completing that certificate while they're there with you at the same time and same occurrence, same place, same everything. Somebody signs it, you identify them and they sign it, they don't get to leave you and have you complete the certificate 6 hours later. That's not contemporaneously. It's happening at the same time and place of the performance of the notarial act. So we're in person together. I identify you, I watch you sign. You're either doing the acknowledgement or the oath or just an official witness or attesting to a signature. I'm completing that notarial certificate immediately upon conclusion of that. That's when it happens, not at a later point in time. I'm completing the entry in my journal at that same point in time. So contemporaneously with the performance of the notarial act, it must be dated and signed by the notary public. The signature shall be the same manner as on file with the clerk of the court. Identify the signature, identify the jurisdiction in which the notarial act is performed, contain the title of the notarial officer, and if the notarial officer is a notary public, indicate the date of expiration, if any, of the notarial officer's commission. So on your certificate, the notarial certificate, it should always start with state of Maryland. That's the jurisdiction, right? You're in Maryland. You can't notarize elsewhere. The county in which the notarial act was performed, or Baltimore City. So we talked about an example earlier where I'm commissioned in Baltimore City, and say I'm down at the ocean, I'm at Ocean City, I'm on vacation, and I take my notary stuff everywhere, and somebody says, Mike, I need a notarization done for me. If I'm completing that notarial certificate, it's going to be state of Maryland, county of Worcester, because I'm in Worcester County, which is where Ocean City's at in Maryland. That's what's going on the certificate. My state would say Michael Schlein, Notary Public, Baltimore City. But the certificate is explaining what is true at that moment in time the notarial act is occurring. Where are you? You're always in the state of Maryland. What jurisdiction are you in? Well, that depends on where you're at, right? If I'm down here in Annapolis, it would be Anne Arundel County when I notarize. If I'm down in Largo, it's going to be Prince George's County. Or if I'm over in Rockville, it's Montgomery County, right? So that depends on where you're at the point in time in the notarial act. And then who's there in front of you? What are they doing? Are they acknowledging? Is it an oath? Is it an official witness? Is it a certified copy of a record? The certificate is explaining what's happening on this notarial act: where, when, who, what, right? Who, what, when, where, why, how. Notarial certificates. Notary public may not affix their signature to or logically associated with the certificate until the notarial act has been performed. So in other words, don't complete the certificate before the person has been identified and signed the document or taken the oath or acknowledgement or affirmation. The notary public shall affix an official stamp to or emboss an official stamp on the certificate. The certificate shall be part of or securely attached to the record. A lot of folks will ask us, what does securely attached to mean? A lot of folks will ask us if they can write the certificate on the record or if they can stamp the wording on the record. Well, that's one way of securely attaching something to the record, right? So securely attached to is the phrase in the law. If a notarial act regarding an electronic record is performed, the notary may attach an official stamp to or logically associate an official stamp with that certificate for that electronic record. Getting into the nitty-gritty here, acknowledgments. One type of notarial act is an acknowledgement. It means a declaration by an individual before a notarial officer that the individual has signed a record for the purpose stated in the record. And if the record is signed in a representative capacity, the individual signing the record has the proper authority and signed it as the act of the individual or entity identified in the record. So think about in that second scenario, maybe the president of a company signing something on behalf of the company, right? Representative capacity, an individual signing it for a company, or maybe for somebody else that they are acting in a representative capacity of. So how are we taking an acknowledgement? The following is a step-by-step process for completing an acknowledgement. You're going to start seeing some of these points over and over here for every type of notarial act. And we talked about some of the kind of the big five earlier. You're going to see them every time on here. The person making the acknowledgement must personally appear before the notarial officer, whether that's in person or using communication technology. There's still personal appearance. The notarial officer must properly identify the person requesting the notarial act. Record the details of the notarial act in the notary's journal. Some might ask, why is this here and not at the end? And what I'll say is that when somebody's bringing a notarial act to you, you're identifying them, you're getting their information. It's good to make the record then and there. Sometimes things happen that cause you to not notarize a document. Maybe you can't properly identify somebody. Maybe there's a competency or duress issue that you have to address, or somebody, you can't satisfactorily identify them at all. You've got the information already written in your journal. Should they have to go away, you already have it written down. You can make a note that you didn't complete the notarial act and why. So there's a record of it. Should it ever come back up later, you can look back on that record and see what happened and why. So recording the details of the notarial act in the journal. If the document's not already signed by the person executing the record, observe the signing of the document. Take the spoken statement of the individual executing the record. The person making the acknowledgement must state to the notary public that the document constitutes his or her act and deed. So whoever signing it, they are constituting that it is their act and deed to execute this record. Going back to item 4, where it says if it's not already signed by the person executing the record, observe the signing of the document, that obviously means then as well that maybe somebody signed this record before it came to you. And in that case, if you're doing an acknowledgement, they can simply acknowledge that they signed it as well after you satisfactorily identified them, and then take the acknowledgement that it constitutes their act and deed. Complete and sign the notarial certificate on the records, the next step, including the expiration date of the notary's commission if it is not on the notary's stamping device. Sample acknowledgement certificates can be found in the notary handbook. And I'll throw a link in the chat box here at the end to the section of the law online where you can pull the exact wording for these notarial certificates as well. Last step is apply the notary stamping device or notary seal to the notarial certificate on affixed or logically associated with the record. So completing the certificate, you're going to do this. In this case, there's a certificate that talks about acknowledged before me on such and such a date by whoever is acknowledging that certificate. The wording in number 6 in the parentheses, the certificate, we talked about proper notarial certificates having a notary's expiration date noted somewhere in them. So if a notary seal, if it does not include the notary's expiration date, you need to make sure the expiration date is a part of the notarial certificate. Next type of notarial act, verification on oath or affirmation, just means a declaration made by an individual on oath or affirmation before a notarial officer the statement in a record is true, or that a remotely located individual has the identity claimed. So a statement of truth by the person executing the record, not by the notary, right? The notary is not swearing to the truth of what's in the record. The signer is. So an important distinction to make there. Folks every now and then will ask us, hey, what if the person is making a false statement? You know, am I responsible? Well, if you know it's a false statement, don't notarize it, right? But if you don't always know that. And if you don't know that, you're not responsible for somebody making a false oath or affirmation in a record. So how are we going to do a verification on oath or affirmation? So when it comes to the person attesting to the truth of something in a document, the person making the verification oath or affirmation must personally appear before the notarial officer, either in person or using communication technology. The notarial officer must properly identify the person requesting the notarial act, record the details in the notary's journal, observe the signing of the document. And in this case, you need to observe the signing of the document. The reason is that the notarial certificate that's going to be on that document or attached to it says sworn and subscribed before me. In other words, they swore to it before you and signed it before you. Take the individual's spoken statement that the individual swears or affirms that the contents of the document are true, either on the individual's personal knowledge or to the best of their knowledge, information, and belief. Complete and sign the notarial certificate on the record. A sample certificate, again, can be found in a notary handbook, and I will throw the link in the chat box to the law itself, which is exactly where the handbook is pulling it from. And again, making sure the expiration date, if not on the notary's seal, is on the notarial certificate. Apply the notary stamping device to the notarial certificate that is on, affixed, or logically associated with the record that's being notarized. So again, type of notarial act. This is one where the person is swearing to the truth of something. Usually in this notarial certificate, you're going to see the phrase sworn and subscribed. If it's an acknowledgement, it says acknowledged. If it's an oath or affirmation, it usually says sworn and subscribed. And those are your telltale signs of whether it's an acknowledgement or an oath or affirmation. Oath or affirmation, same legal meaning. One reference is an oath usually to a reference to a divine being. An affirmation is just a regular sworn statement without reference to a divine being. Witness or attest to a signature. So no notarial officer who witnesses or attests to a signature shall determine from personal knowledge or satisfactory evidence of the identity of the individual that the individual appearing before that notarial officer and signing the record has the identity claimed. This is the certificate that a notary should attach to a record when an individual requests the notary to notarize their signature. So somebody says, hey, I need my signature notarized. They're just asking you to witness or attest to the fact that they signed, or they're attesting to the fact that they signed something. This notarial act essentially replaces what was previously known as notary as official witness. So folks that have been a notary a long time, prior to October 1st, 2020, you used to just date, sign, seal, my commission expires. You didn't attach notarial certificate wording if you're just acting as an official witness. Well, now you do attach notarial certificate wording, and you attach the certificate wording that indicates you're acting as a witness to their signature, or that they're attesting to the fact that they signed that document. So how do we do this? Again, step by step. The person signing the document must personally appear before the notarial officer, either in person or by using communication technology. Notarial officer must properly identify the person requesting the notarial act, record the details of the notarial act in the notary's journal, and if not already signed by the person executing the record, observe the signing of the document. If that document is already signed by the person executing the record, have the individual attest to the fact that they did sign the record. And then you're going to complete and sign the notarial certificate on the record. If no certificate is present, you're going to attach the notarial certificate. And in this case, the one that says that you either witnessed them sign the document or that they attested to the fact that they signed the document. And then apply the notary stamping device to the notarial certificate on, affixed, or logically associated with this record. So a lot of folks will do an official witness or that somebody's attesting to the fact that they signed it. This is that notarial act. It's still a thing. It just now it needs a certificate effective October 1, 2020. It needs to have that notarial certificate. Again, copies are in the handbook. Exact wording that's in the handbook can also be pulled directly out of the law. Next type of notarial act, certify or attest a copy of a record. A notarial officer who certifies or attests a copy of a record or an item that was copied shall determine that the copy is full, true, and accurate transcription or reproduction of the item or record. So what are we talking about here? What are we doing when we're certifying a copy of something? The person requesting the notarial act must personally appear before the notary. Notary still needs to identify the individual, record the details of the notarial act in their journal, right? Those first three things aren't changing. It's a theme here, right? Every notarial act, those are your first three steps. A personal appearance, identification of the person requesting the act, recording the details of the act in the notary's journal. If the copy of the record was not already created by the person requesting the notarial act, the notary can observe the copying of the record. The record was already copied by the person requesting the notarial act, examine the original and the copy to ensure it's a full, true, and accurate reproduction of the original, and then completing and signing the notarial certificate on the record. If there's no certificate on the record, affix the certificate from the handbook and law that is appropriate, and then apply the notary stamping device to the notarial certificate on, affixed, or associated with that record. Important thing to explain here when we're talking about certified copies, the notary, if you were to actually go in and read the certificate wording, is simply completing a certificate that explains that it's a true copy of a record in somebody's possession, whoever's requesting the notarial act. The notary is not saying that, yes, this is a true copy of their ID or passport. It's saying that it is a copy of a record that is in that individual's possession. So the notary is not on the hook for verifying that that's a true document there, or on the hook for doing research to verify that information. They're simply notarizing that this is a copy of something in the individual's possession that's requesting that notarial act.
Mike, it's important you have that on, if you'll back up one slide, please. Number 5, it's really critical because there were some questions in the chat box. You have here that including the expiration date of the notary's commission. It is important to include your notary commission expiration date. Sometimes it's on the stamp, but if it's not on the stamp, you need to write it on that document, on that certificate. Okay?
Yep, exactly.
Any misunderstandings that may have been going back and forth in the chat box, so they must have the expiration date.
Yep, got to be on every notarial act. Most of the time, you're going to see it in a certificate. Sometimes folks will put their expiration date on their notary seal, their stamping device. You don't have to put it on your stamping device as long as it ends up in the notarial certificate.
Right.
Got to be one of the two.
And you have to witness every single signature, whether you know them or not. You've got to witness it.
Oh yeah. Well, I'll pile onto that here for a second then. One of the most frequent questions we get asked about these notarial acts is, well, I know them. I notarize for them all the time. Do I really have to watch them? Yep, every time. Do I really have to identify them? Yes, every time. Now, you may use personal knowledge to identify them. You may not make them show you them your license every time if you know them personally, and you're notarizing for them all the time. But you still need to watch them sign that document all the time if it requires you, or they still need to bring it to you and attest to the fact that they signed it in certain situations where that's allowed. But you still need to follow the rules every time.
And it doesn't make a difference if it's your boss. He said, well, you know me, I just signed it, you know my signature. You're still obligated to witness the signature.
Yep. Still got to record it in your journal every time as well. Mm-hmm. Each and every time. Always a record of every act, following the laws that are required for every act. Not to hit that too much, but I don't know if that can be said enough. We get that question so often, and everybody's busy, everybody's got a lot to do, but you're required to follow the law, and you're required to do these things each and every time you notarize, and you need to do them each and every time you notarize if you want to be a notary. Follow the laws, right? And follow the rules, and anybody should understand what you're required to do and work with that. And the reality is, I'm so busy. 30 seconds, 1 minute to do it the right way. We, as much as we may not think we have the time, we have that time. We have that time. So there are ways to do that and do it efficiently. But got to follow the law every time you notarize. So on to the next notarial act, certify a tangible copy of an electronic record. So a notarial officer who certifies a tangible copy of an electronic record is an accurate copy of that electronic record shall reasonably determine whether the electronic record is in a tamper-evident format and personally print or supervise the printing of the electronic record onto paper or other tangible medium. One might ask, how do I know it's tamper-evident format? Well, if you're a remote notary, using a remotely notarizing electronic records, you're using the technology of a RON vendor, and they have to have technology that allows it to be in tamper-evident format. So the technology provider can assure that.
Yeah.
Certifying a tangible copy of an electronic record. Again, what are we doing here? A person must personally appear before the notary. In this case, we're turning electronic into tangible. So you're there in person. Notarial officer properly identifying the person requesting the act, record the details of the act in their journal, determine that the electronic record is in tamper-evident format, personally print or supervise the printing of that electronic record onto paper or other tangible medium, complete and sign the notarial act on the tangible record, certificate already there, affix the notarial certificate that does this, that shows that this is a certified copy, a tangible record that's a certified copy of the electronic record, and then apply the notary stamping device onto the notarial certificate that is affixed to, or logically associated with the record. Protesting of a negotiable instrument. It's unlawful for any notary public to sign and issue any protest except in the form prescribed by the comptroller. A notarial officer who makes notes or protest negotiable instrument shall make or note the protest in accordance with Commercial Law Article of the Maryland Annotated Code. Commercial Law Article of the Annotated Code 3-505B states that a protest is a certificate of dishonor made by a United States consul or vice consul, or a notary public or other person authorized to administer oaths by the law of the place where the dishonor occurs. It may be made upon information satisfactory to that person. The protest must identify the instrument and certify either that the presentment has been made, or if not made, the reason why it was not made, and that the instrument has been dishonored by non-acceptance or non-payment. Then the protest may also certify that notice of dishonor has been given to some or all the parties. A lot of words there, not something you commonly see in the world of notaries these days. And a protest is not a requirement except upon dishonor of a draft which on its face appears to be either drawn or payable outside of the United States and its territories and the District of Columbia. So this is only something you will ever see if it involves something that's happening in a place that's not inside the jurisdiction of the United States. So in other words, foreign country would be the only time you would use this protest. Matters regarding dishonored negotiable instruments are found in the commercial law 3-501 through 3-515. Suggest if anybody has any further questions about this, check out that section of the law to do a little more reading about protesting negotiable instruments. So in review, notarial certificate is required for every notarial act that a notary performs. The oath or affirmation is a declaration made by someone before a notarial officer that the statement in a record is true, or that a remotely located individual has the identity claimed. The notarial officer who witnesses or attests to a signature shall determine that the individual appearing before the notarial officer and signing the record has the identity claimed. Acknowledgement is made to the notary public. It is not an oath or affirmation of truth. It is a statement that the individual has signed the record for the purpose stated in that record. Notaries can certify a copy of a record that's in someone's possession and certify that a tangible copy of an electronic record is an accurate copy of that electronic record. So the different types of notarial acts that you're going to commonly perform. So with that, Kathy, I'm going to turn it back to you.
Thanks, Mike.